Okay, I've got to do one more thing, so I'm gonna pause the recording. Okay, so we are ready now, and it is now week number four. Week number four of Introduction to Criminal Law. And so I want to encourage each and every one of you to follow all the information that I'm going to be providing for you. 4 weeks into it, that means that by the time we have our next lecture, which will be week 6, we will be halfway through with this course. So I do encourage you to make sure you get your assignments in, and so that I'll be able to see that you are keeping up the pace. So let's go ahead and let's get started right away. I'm going to share my screen, and you can see the information and details about me, reminding you as students that you can feel free to call me, text me, or email me any hour of the day except the 25th hour of the day. I'm sure that by now you got that one all figured out. And then scrolling down, the written assignment for this week is about rape shield laws, and this is your scoring rubric. Make sure that your paper is 2 to 3 pages in length, otherwise you'll lose a point. And then you'll get 5 points for satisfying the requirements that are listed here, 5 points for the other requirements that are listed after that, and then 5 points from the other. And then, of course, you will lose points if your APA is not satisfied. Your points that you lose will be 3 points, and so you want to make sure that you also don't have any spelling or grammatical errors. So it's a total of 20 points altogether. So you want to make sure that you complete all the requirements for that. I want to scroll on down again and remind you that your next course project is not until week 8. So what's going to happen between now and the next lecture is that there's no course project. As I had told you earlier, after week 3, course project, week 4, 5, 6, and 7, there are none. So 8, though, once you get to 8, though, week 8, all the way through to the end, there's going to be course projects. You can see that 9, 10, and 11. And then, of course, your discussion post rubric is also included as well. You guys have been doing pretty good with your discussion posts. A few of you have had very brief posts. Remember, I said at the very beginning of the quarter that your posts should be detailed. Don't just yes or no or one-liners. If you do make a comment, make sure that you elaborate on it and provide enough information so that I can understand that you actually have taken some time to think about your answer, not just a little short answer. In addition, I encourage you again to reply to more than one post. It makes the discussion forum go much better. And then our live lecture, as you can see the schedule that's here, that it says beginning January 9th, 2017. Obviously, that's not right. So it was 2018 that we started this. So you have lectures for week 2, week 4. Then you'll have 3 more after this, 6, 8, and 10. And then, of course, I always include the links for the recordings for the open house, which I sent you, and then your week 2. At the end of this lecture, I'll be including week 4 as well. So let's move over and let's get straight to the announcement for the week. Crimes against people and property, which I'll be talking about in just a few minutes. And to prepare for that, Chapter 7 and 8 of Criminal Law and Procedure, you should have previously received the PowerPoints that I sent you through email on Sunday. And then complete the activity, Crimes Against People and Property, which we'll look at very briefly. And then reminding you that our lecture will take place as it is right now, and then the link for the lecture. And then be sure to participate in the discussion assignment, robbery, burglary, and theft. Some of you have already done that. And note that the initial post is due tonight, Tuesday. Some students got caught up, and I don't know if it was this class or the other classes I teach, thinking that because we started on the first week with Wednesday, that all initial posts are due on Wednesdays. No, they're due on Tuesday. And so tonight, 11:59 p.m. Central Standard Time. Your reply posts, Saturday, 11:59 p.m. Central Standard Time. Finally, the written assignment, rape shield laws, and the quiz. I do encourage you to do your quizzes at the end of the week after you've had a chance to process the material, go through it, and then we will be able to see higher scores. Sometimes students want to go ahead and dive right into the quiz. Just remember, in this course, the examinations are based on the quizzes, and that's the only exams that you have in this class. Other than that, you're doing papers. And then please take time to complete your mid-quarter student survey. Take a look at those. And then, of course, my motto, start strong, continue to be strong. And then my motto, adversity is a springboard to success. You know what that's all about because I shared that with you during the open house. For those of you who haven't had a chance to listen to that, you need to go back and listen to it. So now let's go for a minute and review our schedule again for the week by looking at the course calendar. And you can see that here we are right here this week. Your reading assignment on Monday. Your initial post due tonight, along with your lecture taking place right now. Your reply post on the 27th, which is Saturday. And then, of course, your written assignment and quizzes, and then try to do your mid-quarter. And then next week, which we won't have a lecture, but I will be still sending you the PowerPoints, complete the reading assignments, then your initial posts, and then, of course, on the 4th, you will complete your written assignment and then quiz as well. So now let's go right into the module. And this again, a lot of repetition here, but this is clear that you will understand what you're supposed to do by listening to the lectures. Again, this is the fact pattern, and you're going to read the fact pattern and answer these questions and provide the details. Remember, it is a 2 to 3 page paper. That means what it says. It's not 1.5, 1 3/4. It means at least a minimum of 2 pages. And make sure that you research the terms. Make sure you understand the term in camera, what that means, and those kinds of things. And then these are the questions in this area here. And so you're going to submit your assignment, of course, by Sunday. Make sure it's a Word document. And then your discussion, again, involving what Debbie did uh, to Larry. And you're going to determine whether or not Debbie is guilty or could be prosecuted for robbery, burglary, theft, either one of the above, two of the above, or three of the above. Elaborate and explain why you reached a conclusion on your discussions. And then, of course, your quiz there. Okay, let's move along. And lesson content. So we're going to deal with crimes against people first, and then against property, and then the degrees of theft. We're gonna talk about that as well. Again, repeating the assignments. I want to remind you that research is always required. You'll see down here at this section, if you look under each assignment, it says study, research, and reflection. So that's one of the things that you always are going to be doing is researching. A student asked about why do we do research? Well, first of all, number one, it's one of the transferable skills, dealing with information literacy, and it is important for you to understand as a student that you will be called upon by your employers to produce reports and for meetings and things of that nature. So it's good to research. I am a natural researcher, having been a lawyer, but as a professor, I still continue to research because things are changing. And then your definitions of assault and battery. I'm going to talk about these: rape and sexual battery, larceny, false pretenses, burglary versus robbery, and again, we're going to talk about those kind of things tonight as well. So now you have a little drag and drop exercise, which I encourage you to do, and it's very simple, shows you how it works. You've got 3, 4, 5, 6, 7, 8, 9, 10, 11. Yeah. So you're going to take each of these and you're going to read it. For example, the first one says, the unlawful use of force against one person against another that entails some injury or offensive touching. Anybody want to take a shot at which one it is? You can type it in and I will see it in the chat. Which one fits that? Which one of these answers? Unlawful use of force against one person against another that entails some injury or offensive touching. Which one? No takers? Okay. Battery seems to be the choice. So let's see. And you're right. It is battery. It is battery. And you do the same thing with these others. Do one more. The willful and malicious destruction of any real or personal property belonging to another. Which one? Edgar says malicious mischief. Kristen says that. Let's see. And you are right. Everybody says that. So that's correct. So you go through and you do each of these. Now, what you're really doing, whether you realize or not, you're studying for your quiz by doing this also. So I'm not going to do all of them. I'll let you go ahead and do them because I want to make sure that I have enough time to cover the lectures adequately. Because whatever point I am is covering the chapters, at 10 o'clock I will adjourn or maybe a few minutes after, but within that period of time. Okay. Any questions about any of the assignments from any of you? And if so, you can type that in the chat box. Any questions concerning the assignments for this week? And if you do type it, try to take it off privately and put it so that everyone can see it. No questions? Okay, so it's pretty clear what is expected for week 4's assignment then. All right, so now let's go right into our lecture. All right. All right. So let's talk about Chapter 7, offenses against persons. And so dealing with individuals, you're going to discover, as we go through this particular chapter, that there's a high level of protection provided for persons. You're going to see it's a little bit different when we get to the property issues. Why? Because we value life. So let's dive right in here. So crimes against persons fall under state law, and each state has a different makeup of the laws. For example, assault and battery were misdemeanors under common law. Well, under some statutes today, simple assault and simple battery also are misdemeanors. So can anyone tell me, how do we know if a crime is a misdemeanor or a felony? Can you tell me how do we know that a crime is a misdemeanor? Anybody? You can type in the chat box. Smaller petty crimes. Yeah, okay, a little more specific than that. You're heading in the right direction, though. Good guess. Any others? How do you know that something is a misdemeanor? Yeah, that's also value of property taken and injury sustained. Yeah, okay, it's easier than that. Well, here it is. If you are going to receive a sentence of a year or less, it is a misdemeanor. If it's a year or more, then it's going to be a felony. And the rule of thumb usually is 364 days of a sentence that you serve is considered a misdemeanor. And if it is a year, 365 and above, it's a felony. And it is based upon the seriousness of the offense. Batteries and assaults generally are not going to fall under felonies, unless we point to the fact that if you do it on a public officer, that doesn't necessarily mean just a police officer. It can mean a person such as a mail person, a person who delivers packages, also not just the mail, but UPS, FedEx, and those kinds of things. Also now Amazon is doing the same thing. You can also find it if you're dealing with someone who is providing a service like a utility, phones, internet, same kind of things. Aggravated assault, so they fall under felonies because we want to protect those individuals who are performing those services. Aggravated assault and aggravated battery are also um, uh, felonies as well. So how do you know if it's aggravated assault or aggravated battery? It is not just, for example, okay, simple battery is striking someone with a weapon, or even, for example, find yourself in a situation where you are a martial arts person and you're registered as such, then your hands become deadly weapons. And so they are oftentimes considered as dangerous, dangerous individuals. So then it's considered as aggravated. So then you also consider it if, for example, you even put a gun on someone or a weapon to try to scare them, then it moves into the aggravated. And it moves more across the line of seriousness than just simply assault and battery. Now, you should be aware that people usually hear assault and battery. Assault can take place where a person knows that they're getting ready to be struck. But battery can come not just with assault and battery. It could just come with a person who is not aware, and the person sneaks up on them or catches them by surprise. And offensive touching, as we talked about earlier, or striking that individual, that person may not have realized it, so it's not assault and battery. It's battery in itself. All right, very simple. Assault, the attempt. So it's an attempt. Even so, if you don't touch a person, it's assault. Aggravated assault is, as I said already, threatening with a weapon or intent to commit a felony. Battery, the unlawful use of force against another person that entails some injury, doesn't have to be injury, or offensive touching. A person, and you know what? It's not like you accidentally brush up against somebody, that kind of thing. But you can find yourself doing crazy things, such as kids have, like grammar schools even do this crazy thing, sometimes try to trip somebody. Well, that's considered as a battery. Then we get into an aggravated battery, where an instrument designed to inflict great bodily harm is involved, as I said a few minutes ago. So that's that about assault and battery. Again, I'm not going to cover these, but I will say to you that some examples of assault is missing a person, shooting in direction, threatening someone with a weapon. Aggravating factors are if the weapon is deadly or could create great bodily harm. The battery, hitting or pushing someone, offensive touching, using excessive force to break up a fight, intentionally tripping another. I was talking about that a few minutes ago. Using excessive force in disciplining a child. So that's an argument, though, that will continue, and you'll see an example of what I'm talking about in just about right here. So here's an example, and I was talking about in terms of corporal punishment. Says there's no consensus about what is great bodily harm. And another question is whether psychological harm should be taken too. So the question is, at what point does spanking a child become child abuse? So here's an example here. California says child abuse is the willful infliction of a cruel or inhumane corporal punishment on injury that results in a traumatic condition. So it has to be willful, and it has to be cruel or inhumane. For example, a case involving a 4-year-old where this young kid threw his breakfast at his mom because they weren't going to go to Disneyland. So the mother puts the child in timeout. So the child still continues and then hits the mom and spits at her. Well, the mom wants to spank him on his butt, but misses and hits his head instead. kid falls on the floor, hits his head on the floor, and the doctor diagnoses a concussion. So the question is whether or not she violated that California law. And I would say probably not, because it wasn't a willful infliction or cruel or inhumane corporate punishment. The child was doing something that was kind of the child was out of control. 4 years old, so you have to try to put them in check. Now, I don't ever want to see any jurisdiction come out with a law that says you can't exercise corporal punishment on your child. I would fight that as a lawyer, and I have seen that attempted. I represented some people when I was a lawyer where there was an attempt to bring simple cases against parents, saying that the children have a right not to be involved in corporal punishment. That's not going to fly. And actually, that contributes to a lot of things that happen with youth. As my kids understand, if they say to me, you know, I have my rights. If you strike me, I'm going to exercise them. I'll have to show them the door. I don't, you know, somebody's going to have to come get them because you're not running my house and that kind of thing. Anyway, you understand, you get the whole point in a nutshell. And, you know, the idea, people, is that we want to make sure that we're not violently trying to harm a child. And this mother wasn't trying to do that. Okay. Some prosecution and some possible defenses. Prosecutors, all they have to prove the act and general, not specific intent, general intent for the overall circumstances. And we pretty much know what that is when it happens. Prosecutors with aggravated assault just have to prove specific intent. In other words, that they did something further than just try to strike the person or threaten them, but they intend to do great bodily harm or commit a specific felony. In that case, then we get to aggravated assault and battery. Some possible defenses that could be raised by those individuals representing people, and I have raised some of these, is the statutory law defines the degree of force that can be used by teachers, police. There's a lot of that dealing with law enforcement, that the incident was unintentional, as I was talking about a few minutes ago with that child. The circumstances, totality, were reasonable, or an individual was exercising self-defense and exercising it at the level that's necessary to protect themselves. For example, if a person is striking somebody with their hands and they take out a gun and shoot them, then they might have a problem because that's going to be excessive force. They might say, well, the person, you know, had me in fear of my losing my life. It would take a whole lot of factors involved. Like, for example, maybe the individual was a big person, a huge person, a muscular person, and the person that was being attacked was smaller, or a male against a female. Those kind of things. It depends. There's a whole lot of circumstances, but that's operated and determined on a case-by-case basis. Mayhem. Mayhem is not something that we really deal with anymore because we deal with it pretty much in statutes where it was willfully and maliciously injuring someone so as to render the person not able to fight themselves. Some statutes include injuries that disfigure an individual, such as, let's say, for example, you pour some kind of caustic solution on that person, hot water or something, then you can get to the point of mayhem. Prosecutors typically just have to prove general intent with mayhem. And the crimes now that we use now instead of mayhem are aggravated murder and attempted murder. Because, again, we've crossed the point where you're performing an act that could possibly result in the loss of a person's life or serious injury to that individual. Whoops, let's go back. Good old hazing. Um, hazing. And, you know, it's interesting. When I came up, there was no such thing. The closest thing to hazing that I knew of was years ago when I was in college. I mean, that's going back to way back. When I first started college, I was in junior college. 1969, they had an organization called Wine by Psi, where individuals would have to ingest so much alcohol in order to become members. Well, they have something like that now. And it ended at the campus where I was because a person ingested so much that they ended up going into a coma and then passed away. But hazing in itself is illegal, and represents danger to an individual. It's defined as the intentional or reckless physical or mental harassment, physical or mental abuse or humiliation as part of an initiation. And that's what I was talking about a few minutes ago. We had one recently here in Illinois. There's been some in other jurisdictions as well. And usually it involves clubs, sororities, athletic teams, and other groups. May seem like foolish pranks, but could result in the death of an individual or serious injury. And many colleges and universities prohibit hazing. And I think in Illinois, we have it on the books that that can be a felony. And then some examples of hazing. I won't go over these. You can take a look at these on your own. Stalking. You know, it's become something that's pretty serious. It usually happens in dating situations, and it oftentimes happens with celebrities or well-known people. But the definition and a jurisdiction such as California, for example, uh, came out with laws protecting individuals and making it a crime. Well, you heard about the David Letterman situation, or there were some others. There was a few people that it resulted in their deaths. I can't think of this young lady's name, who was an actress, and she was killed over a stalking situation. But it's very simply following or placing a person under surveillance, threatening that individual with bodily harm, sexual assault, confinement, or constraint, or placing that person in reasonable fear of bodily harm, sexual assault, or confinement or restraint. And almost every jurisdiction uses those words in the statutes that they have. Says here in 2006, an estimated 3.4 million persons 18 or over were victims of stalking. So it's become a more serious offense. In 1990, California was the first state to make stalking a crime, and I told you why that was. And now the federal statute was amended as part of the Violence Against Women Act in 2000 to deal with stalking as well. During the 1990s, a number of individuals tried to argue that stalking was a violation of their First Amendment right. In other words, they had a right to be doing what they were doing. Well, the point of the matter is you know when you are in a situation where you're making that person feel uncomfortable, and so stalking is pretty serious. Most courts have upheld the constitutionality of the stalking laws. And then we moved into this next slide here, where we have moved up because of technology, and Illinois has jumped on the bandwagon and introduced cyber stalking. And that results from using the internet or texting, social media, Snapchat, or any of those type of things, Facebook, and harassing or threatening a person through persistent online contact, so the person is placed in fear of safety. And again, it's a felony in Illinois. Several other states have amended their statutory definitions to include cyber stalking. Again, keeping up with the fact that we are in a society where technology is heavily involved. Rape and sexual assault. Now, forcible rape, as we are pretty much know, is non-permissible sex or sexual intercourse by force against the will of the victim. It could be male against male, female against female, or male against female, and vice versa. Statutory rape is a strict liability offense. Now, when I say strict liability, what that means is that you don't have to knowingly commit the offense. In other words, there is no mens rea, there's no mental requirement. All that has to be proven is that the person was underage, and it doesn't matter whether they look. There are people who try to argue, oh, look, they looked like they were of age to give consent, or they gave consent and they turn out to be a minor. Doesn't matter. They can't give consent, and it says clearly, and it's for the protection of the minors. The marital exception, which remained valid in England until 1991, said that a person could be charged as an aider or abettor if they assisted or procured another man to rape a wife. And you'll oftentimes discover that even with married people, it can happen. How does it happen? Generally, it happens when there either is an order of protection or they've been separated, and those kind of situations occur. But generally, it doesn't happen when the husband and wife or partners are in the same house living together with each other. Generally, it doesn't, but it can. Statutory rape, I already kind of talked about that. Protect young women. Well, now it's protecting young men and women. And the ages vary from 16 to 18. Force and consent are not relevant. Women under the age of 16, 17, or 18 are unable to give consent. And a strict liability offense, consent, again, is not relevant. And they said it was okay. So what? You go to jail. Or you end up being found guilty of statutory rape. By the way, if you do, you're going to be required in most jurisdictions to register as a sex offender. So you're going to have other problems further down the road in your life. There is some people who have opposed statutory rape, say that the law is out of touch. Nobody's asking anybody whether it's out of touch. The law is on the books, and you have to obey the law. And it's, once again, we need to protect our youth and protect them from making bad decisions. So the law steps in and protects the individual and takes away their desire to have sex in a situation when they shouldn't. Some say it deprives women in their late teens of exercising a personal choice. Once again, speaking as I said, I have daughters. Doesn't matter. You still have to apply the law as the way it is written. It's not based upon what you see. You cannot argue. They look so mature. They look so adult, or they dressed in a certain fashion. Doesn't matter. It's irrelevant. It is a strict liability offense. Period. So what has happened, as I said earlier, is that rape laws are gender neutral. criminalizing forcible sex between spouses under certain circumstances like the ones I described, expand the definition of rape to include using foreign objects as well, dividing the offense of sexual battery into classifications and degrees based upon the circumstances. One of the major reforms in the rape laws has been enacting what we call rape shield laws. And this goes to an assignment that you have this week, and so you need to really pay attention to this. In many jurisdictions, statutes were passed called rape shield laws to protect the identity of a rape victim and or prevent disclosure of a victim's sexual history, because it was determined that what was taking place, and I can tell you this as a lawyer, I didn't do a lot of rape cases because I couldn't, I wouldn't. And so anyway, my point being is that what was taking place is that the victim would oftentimes not want to come forward with the information to convict an individual, or it took a long time because they were treated by the attorneys, even the prosecution, as if they did something wrong themselves. And thus, rape shield law says, no, you can't use the previous sexual history of an individual in a rape case. And it made sense. And then dealing with rape shield laws, not only to protect them from other things, but embarrassment and humiliation, as I was saying. And it was an attempt to increase the ability of individuals to testify by removing or minimizing those things. The theory is that the victim's prior sexual activity is irrelevant because it says nothing about the question of whether or not that person was raped. And certainly I can tell you this, that even if a person is old enough, because they didn't resist is not an adequate defense either, because you should be aware that rape itself is a crime of power, where the individual is controlled by the person who commits the offense. So the laws represent those individuals in protecting them from as much as possible humiliation that they may encounter. It's already a tough enough crime. And so judicial reforms, victims of rape should receive no more scrutiny than other crime victims. In other words, you could be found a victim of another crime and you're not demeaned. You shouldn't. And women, as I said, should not be required to resist as well. So we get to, before I get to sodomy, I want to go back to rape shield laws. And so what happens with the rape shield laws is that oftentimes the testimony of individuals is done in what we call in camera. In camera proceedings, as you'll discover from your research, involve where the individuals are in chambers with the judge, not out in the public, and they're able to determine what actually happened in those kinds of things. So and the judge will then determine whether or not it is necessary to provide that information in the trial. Again, it's a move to protect victims of rape. Moving right along, sodomy, anal or oral sex between persons, or sex between a person and animal. It can be consensual or unconsensual. If it's consensual, it's legal. Unconsensual sodomy is the same way as rape. Consensual sodomy is not a crime, and the United States Supreme Court has held that states may not prohibit consensual sodomy between same-sex partners for obvious reasons in our country today. The bottom line is that it's gender neutral, and so it shouldn't be a determining factor whether or not it's a male or a female, two females, two males, and those kind of things. The point of the matter is, if they are doing it consensually and they're at the age where they can give consent, it's perfectly legal. I'm not talking about the moral side. I'm talking about what the law says. So then we get to, as I was talking about, when you commit a sex offense, you register, and everybody's familiar with that. Based upon the Megan's Law, where a young lady was, I mean, it was really bad, really bad. So the law came out in 1994 that requires, upon release from prison, that offenders have to register and include their address, and it's public information. So there are people who debate that issue, saying that the laws are overly inclusive, and I understand some of the points. For example, a person should not be labeled a sex offender for petty offenses such as urinating in the park. And I'm not talking about a person who's openly, but a person who can't get to a place and they try to go into a private area, and then police stop them, arrest them, and then no. I think that's a problem, because then that person is a registered sex offender. I think that we need to clearly understand what was the intention of the registration laws. These were individuals who committed acts of violence upon individuals, and that's not the same thing there. And we're not talking about flashers or things like that. Anyway, there's another point that laws punish people based on status. Well, rather than wrongful acts. Well, here's the issue. It is statistically proven that individuals who are pedophiles or serial rapists, when they are released, there's propensity to commit those acts still going to exist. There they have a problem that is mentally happening in the head, but the fact of the matter is the public needs to be aware of who's around them. I can tell you that a few years ago, my wife and I, we were looking at some houses that we were going to move into, and I said to her, I said, these are nice. I said, but let me check, see who's on this block or who's within a radius of a mile or half a mile of that area. And to my surprise, I found that even on the block, as a matter of fact, one of the houses that we were looking at, the people across the street and next door to where we were going to look at a house, and we told the realtor we're not interested. But I have children, and I can tell you this, that years ago, when, well, I have a 9-year-old now, but when our older kids were at the bus stop in an area that we used to live, there was a car that was always at the corner, and we would see that car. And so kids would get off the bus and head in that direction. Well, eventually, we started pointing it out to law enforcement, and so they came upon that individual, and that person was a registered sex offender, a pedophile at that. So it's important for people to understand for the protection of everybody. Go back, jump. Okay, anyway, Smith versus Doe held that Alaska sex offender registration may be applied retrospectively to defendants who were convicted prior to the implementation of the act. 2 defendants challenged the statute on the basis that the statute was punitive and in nature. In other words, it was another continuation of punishment, and that these kind of crimes could not be applied retrospectively, or either turn it into what we would call a after the fact law. And so I don't know why I'm drawing a blank on the legal term, because I've said it many, many, many times. But a person being charged with a crime after they did it, but it was not in existence when they did it. So the court disagreed, stating that sex offender registries are non-punitive. So it's not to punish anybody, but it's for the protection of the public. And so that's that's the truth. Again, dealing with sex offender laws. Again, person found guilty of being a party to a crime of child molestation because she let her 15-year-old daughter have sex with a boyfriend. The young couple later got married, but she spent the rest of her life publicly branded as a sex offender, and guess what? Had to register, and those kind of things. So again, the whole point of the matter is, as I said, is to protect the public. Child abuse. Child abuse, actions that physically or mentally, emotionally endanger the welfare of a child. You know, there's been an increase in child abuse. And, you know, one of the reasons why these types of things have happened is because of economical reasons. But there have been a whole lot of these kinds of things. Man, in, I think it was California, where these 12 kids were held a long time by their parents, and now um, one escapes, the 17-year-old, and reports the abuse that was taking place for years and years and years, and then finally the public was, given the information of what was taking place in those homes, in that home. And so child abuse is something that is taking place. Assault, battery, aggravated sexual neglect. Um, so children are vulnerable. And so these are strict liability crimes to protect the children themselves. And they're most of the time misdemeanors as opposed to felonies. But the statutes require medical professionals and social workers to report instances of suspected child abuse. And that's because of the fact that they're mandated reporters. In most jurisdictions, we even as instructors, we have the same situation. Now, I know our program is online, but we have things on campus where people come to the campus. And if we suspect or see something, we have a process whereby we report that to our deans, and then they're investigated because we are mandated reporters of those kinds of things. So there's a controversy emerging over the question of whether drug use constitutes child abuse. In other words, a mother carrying a child is using drugs or drinking alcohol or smoking even. There is a question that could be argued or raised. Those of you who've heard my story talk about what happened with my mom, and my mother allowed this guy to physically beat her and then continuously brought him back to the house. And we as children were exposed to that, and seeing that growing up in a home of domestic violence. Well, there's a question of whether or not that constitutes child abuse. I would say it is, because the fact that it mentally could create problems for that child or those children for the future. So that's an issue that could be argued by a prosecutor or not social service agencies. The children, of course, are taken by protective services in many jurisdictions. I have a cousin who, for example, he spent many years working in Hennepin County, the biggest county in Minnesota, as he was a supervisor. And he tells me some of the instances and situations that you'll be surprised. And then I've seen a number of those as a lawyer here in Illinois as well. And then I'm sure you, whatever state that you're in, uh, know exactly what I am talking about. Okay, let's go back. For some reason, this is jumping to spousal abuse. Again, we talked about that a little bit. Physical, emotional, sexual abuse of a husband and wife. Courts can issue protective orders. The Violent Crime and Law Enforcement Act of 1994 says that if you take a person across state line for purposes of committing domestic violence, then the feds can step in. In this case, for example, they give Christopher Bailey convicted of kidnapping, interstate domestic violence, for assaulting his wife and driving her around. And notice what you hear. He crossed from West Virginia into Kentucky and then finally brought her to emergency room. That's a federal offense because as soon as you deal with crossing state lines, then you find yourself dealing with a violation of the federal as opposed to not just the state law. Elderly, again, physical or mental harm to an elderly person, taking advantage of that individual, often handled through state regulatory agencies, and a lot of the proceedings are civil. But Illinois, for example, we criminalize that. It is a felony to intentionally or recklessly cause injury to a vulnerable elderly person. Illinois Domestic Violence Act incorporates that for the protection of elderly. Because you know what happens is that, remember, when you're a child, you're vulnerable, and then you become an adult, and then you reach a stage where you can no longer handle things, and it's almost like you've gone back to the child stage as an elderly person where you're not able to take care of yourself, and someone would take advantage of that and abuse you. For example, in this case here, the Semister case, where Dale and Janice Semister's uncle was brought to the hospital. The hospital staff noticed something, that he had not been fed, was covered in urine and dried feces, which meant there was neglect, and laid in a fetal position that took at least 2 weeks to develop, and so they were convicted under Illinois law of abuse, elderly abuse. You can also deal with that from a financial crimes level as well, as you will see here. Okay, it's not here. It's in another class I teach, that if you take advantage of an individual and take their funds and abuse them, you can run into the same situation. False imprisonment is unlawfully restraining an individual. False imprisonment is not used a lot, and it's usually a misdemeanor unless it falls into an area where, for example, there was some young ladies years ago in, I believe it was Ohio, a guy by the name of Castro. He eventually killed himself, but he held, I think it was Amanda Berry was one of the names of the victims, held them hostage in a home and kept them tied up and sexually assaulted them and so forth and so on. That's an example of what I'm talking about. Scenarios: unlawful arrest by police officers, prison wardens not allowing individuals to release after the time when they're supposed to be released, a storekeeper detaining a person for shoplifting because they believe they don't have an adequate basis. That often results in a civil suit as well. Overzealous male not allowing a female companion to leave without yielding to his sexual demands. Again, because of the gender neutral sex laws, it could also be an overzealous female not allowing their male companion to leave. I mean, how could that be? Well, they can hold a weapon on them or something. There's all kinds of things that happen in those scenarios. when I was talking about earlier, just so you'll know, about the individual, the law changing after an individual does something, ex post facto laws of what I was referring to. That's after the fact. So let's say, for example, you commit a crime, and then at the time you commit the crime, it was not a violation of the law, but then it becomes illegal later. Then in that case, then that law that later would be ex post facto. But with registration requirements coming after the fact, that is not, because as I said earlier, it's not punitive, it's for the protection of the public. Just wanted to clarify that because I was looking at a note that I had here in front of me. Kidnapping is forcible abduction and forcible carrying away of a person against their will. It's a felony. It's a serious felony because you're depriving the individual the right to freedom. Asportation is carrying away property of the individual. The Lindbergh kidnapping implemented the Federal Kidnapping Act, where a person disappears, the baby being taken and taken away, and that is a violation of the federal law. We cross state lines. Some defenses saying no, they didn't move the person or their consent. Remember what I said, that consent issue is not going to go very far in a situation because the person's under duress. Lack of movement doesn't necessarily mean that you took them somewhere else. You kept them from their freedom or leaving or going wherever they desire to go. Child snatching primarily happens in some situations where there's divorce or custody issues. And so we have what we call the Uniform Custody Jurisdiction Enforcement Act, which jurisdiction continues across state lines. But the jurisdiction for the child when it crossed state lines is based upon where they really resided. The Parental Kidnapping Prevention Act, designed to prevent jurisdictional conflict over child custody matters, reduces the incentive of parental child snatching. You can almost be assured that when there's child snatching involved, that 9 times out of 10, it's involving one parent deliberately taking that child from the other, the non-custodial parent, in situations like that. Civil rights offenses where people are protected under the federal and state constitutions so that they're not discriminated against, protects individuals from injury by public officials such as law enforcement or other individuals who are using their office or position to protect them by violating the individual rights of people. Conspiracy against rights, deprivation of rights under color of law. You will find that there's a lot of those kinds of situations that happen in states, but then the federal jurisdiction steps in and federal civil rights laws are applied, and individuals can be prosecuted in those situations. As I've said before in other instances, and I'll say it now, if a person is prosecuted in a criminal case for a civil rights violation or crime in the state courts, and they're found not guilty because maybe the jury was set, maybe there was some racial issues or some sexism involved, maybe some issues where a person didn't give the individual the rights that they had under the Constitution. Well, then, if they're tried under the federal jurisdiction and they are found guilty, some would say, oh, isn't that double jeopardy? No, it is not. Double jeopardy does not apply when it's from the state to the federal jurisdiction. It does not. And then there's a violation of the federal law. The United States Supreme Court upheld a conviction of a judge who threatened a woman to deny her custody. And he said that in order to do so, she had to have sex with him. Well, the court ruled that the judge acted under what we call color of state law, which means he was hiding behind his position, and that that individual was seeking justice, but he was using his position as a judge to force the woman to have sex with him. And so he deprived her of her constitutional right to be free from sexual assault. Hate crimes, more and more now we are having it based on race, ethnicity, gender, or sexual orientation. We're having a whole lot of hate crimes that involve sexual orientation, but it's where a person is biased and commits a violation against that individual or their property. The hate crimes will take a normal crime, like, for example, let's say a battery against a person, but that the battery took place because of that person's race, sex, national origin, or either sexual orientation. Then in that case, it becomes a more serious offense, and a special category has been created called hate crimes. Hate Crimes Prevention Act, which is a federal law, eliminated the requirement that the victim be engaging in a federally protected activity. In most state courts, it enhances the criminal penalties. That was what I was saying when you're convicted of a hate crime. And that's it for that chapter. We've got roughly 20 minutes, so let's go into the next one. Any questions from anyone before I get to the next section? Okay. There being none, I will continue on. Property crime. So now we get to the point now, remember we were protecting individuals. So now we're going to protect property. Now, again, the courts and the criminal laws protect property, but the offenses are not as serious. Even the sentences are not as serious, unless the property crime relates to a possible injury or personal injury or some loss of life or serious injury to an individual. I'll elaborate on that in a minute. At common law, larceny was basically taking the property of another. But now we use the term theft. And that just simply means you deprive the owner of an interest in personal property, and theft is based upon statutes. And false pretenses is where you obtain money or property through misrepresentation, maybe by using someone's check or credit card or something along those lines. We've gotten to now with identity theft that is kind of tied into that, but because of the damage that is done to people's reputation and their ability to be able to obtain credit, it's moved into a higher level, and it has a category all by itself called identity theft. Embezzlement, taking a position of trust or authority to transfer or convert the money or property of another to oneself. I referred to that a little bit when we're dealing with seniors, but that can also happen with when you're the trustee over some funds for an organization or for maybe a child or something like that. Well, the prosecutors simply had to prove that the accused intended to defraud the victim. Receiving of stolen property is also a form of embezzlement as well. So now, dealing with theft, we've moved away from larceny to theft of vehicles, shoplifting, looting, carjacking, and extortion. On the federal approach to dealing with this is manifested in Chapter 18 of the United States Code, annotated. You should be aware that 18 USC, and the reason why it's A is because it's annotated, which means there are cases that have been decided up under that section of the law where you would find it. And so all criminal acts, or should I say most on the federal level, are found in Chapter 18. We as lawyers know that when we're using a federal approach, usually our starting point is Chapter 18. There's some that are not, but most fall under that. So Section 641 places crimes into one category, dealing with embezzlement, theft, or receiving stolen goods. We get to those kind of things when you hear the old thing about somebody use the term, say it fell off the truck, and that doesn't necessarily mean that's a term that's given, but what it really means is that you're buying something that was stolen, maybe from a train that was passing through, shipping cars that are shipping items, and someone might try to sell them to you, and then you buy them. So then you get into a federal violation because we're dealing with interstate commerce because of the traveling across state lines of those items. 659 provides penalties for embezzling or unlawfully taking the contents of any vehicle moving in interstate or foreign commerce from or from the passengers themselves, such as holding up someone on a bus, a train, airplane. Those kinds of situations occur. This chart is actually from your book, and so you can take a look at that. And it shows how it was at common law, and then how early Parliament came to the point of expanding it to these three areas: false pretenses, embezzlement, receiving. But now we deal with shoplifting, looting, grand theft auto, identity theft. Remember, I was talking about that earlier. Computer fraud because of technology, credit card fraud because of what's happening here also, which kind of fits with technology, and then stealing patent, trademarks, selling bootleg stuff, those kind of things. So the modern approach to theft offenses, and most states now include tangible as well as intangible property under the definition of larceny. Newer statutes include other crimes besides theft and impose penalties based on the amount. So that if you find yourself in a situation where a person is taking something, and the higher the value, the more likely that you can find yourself in a felonious situation based upon the value of that property. Grand theft is the most serious aspects of it, and that's a very serious felony, and you can go to jail for a number of years. Petty theft is a serious misdemeanor, but again, remember I told you how you can derive the difference between the felony and the misdemeanor. And then the whole issue about willful design to take goods or services from another without permission or authority, that's theft. That's theft in a nutshell. And you will see that across the board. You'll see that in terms of your assignment that you're doing here this week. Embezzlement. This is one that, there's this guy, Bernard Madoff, had a Ponzi scheme. So what's a Ponzi scheme? Well, that means that this person led people to believe that he was investing money in something, but he really wasn't. He was pocketing that money, but very sophisticated, because what happened is that he embezzled money from so many people. Investors lost 18, not million, but billion. And they were middle-class persons. So it wasn't like, for example, taking advantage of people who were older or were not educated, but there were people who got duped. And so he was convicted, though, of 11 federal felonies and sentenced to 150 years in prison. And so they did a movie about that, and if you ever get a chance to take a look at that. And then they also did I think it was a book that was written about it. But that was one of the serious offenses of embezzlement. Robbery. So now let's get into one of the issues for your assignment for this week. So what is robbery? Very simply stated, taking money or property from a person against that person's will, listen to that, by means of force or intimidation. It's got to be from the person by means of force or intimidation. That's the key. Those elements have to be present. So you ask yourself when you're doing your discussion post, is Debbie guilty of doing this? I'm not going to answer it. Some of you have provided some answers that were good. And even if the answers, you reach a certain point, you can explain why you reached that conclusion. And I read those very seriously. Under common law, robbery was an aggravated form of larceny. So what you did was now you're starting, remember I told you earlier, there are some property crimes that cross over into dealing with the person or possible injury to an individual or force against that individual by either threat of violence or violence itself. So force or violence have to happen before or at the same time as a taking of the property, not later, but at the same time. And so offenses against the person, it usually involves assault or battery. We talked about that already. Under federal law, bank robbery, prosecutor needs only to establish general intent. State law, some states have codified the common law, and robbery is listed in the statute. Other states classify robbery according to degrees. There are first degree, second degree, third. The more serious the offense in terms of force, the more likely it would elevate the classification. Then there's aggravated robbery. We already know what aggravated does, bringing something on other than just threatening the person, but bringing something that places them in fear of injury or death. So in this 1986 Supreme Court case, the Supreme Court held that an unloaded gun is a dangerous weapon. Why, Professor Wright? Because of what it says here. Just the gun itself instills fear. And as a result, it creates an immediate danger, that violence. McLaughlin and a companion had robbed the bank with an unloaded weapon. They said that it was unloaded, but it was, as far as the people knew, it was not. Let me give you an example that happened to me when I was a police officer years ago. A young man walked up to me. I didn't have my uniform on. I never wore a uniform because I was a special investigator, and my gun was a shoulder holster. And so anyway, the young man walks up to me, and he pulls a gun on me and tells me to give him my money. So I told him, I says, okay, just a minute, let me reach down inside my jacket. So I proceeded to reach down inside my jacket, and what I was doing was talking to him, engaging him, but at the same time, I was unbuckling my gun. So I said, okay, here it is, and I pulled it out and held it, ready to fire, and he threw his hands up and dropped the weapon. I told him, kick the weapon over to me, and then lay down on the ground, and then, I put him in handcuffs. Well, guess what? It was a toy gun. It was a toy gun. But I would have been within my right to empty my gun into this young man because of being fearful that I could be killed. And then somebody could say, well, you could tell the difference in a toy gun. Not. And it's not necessary either. And that's why, when I was a kid coming up, we used to play cowboys and Indians, or we would have BB guns and all that. We're in a different time now because of the situations. You can get shot by a police officer or someone else, even just by using a water gun even. And that person doesn't know. And so that's the whole point in a nutshell. that person is placed in fear in this situation from robbery and at the bank. It didn't matter whether the guns were not loaded. Carjacking is going on all the time now. We're having a whole lot of those kinds of things. Taking of a motor vehicle from someone by force, violence, or intimidation. It's been happening a whole lot, especially in Chicago. We've been had a whole series of carjackings. And you know what? They do take cars that are, more of the newer models, but now it's reaching a point where carjacking is taking other vehicles that are not. Let me explain to you why that happens. Is that those individuals commit those kind of carjacks. They'll take them at the gas station while you're pumping your gas and so forth and so on. But anyway, the point of the matter is that they will take those vehicles and then they will commit other crimes. And guess what? When the individuals commit the crime, they don't care if people do get the license plates. Why? Because it's not their car anyway, and the car doesn't tie it to them. So they find themselves doing that. Anti-Car Theft Act of 1992 makes it a crime to take a vehicle from a person. And amended 18 U.S.C.A., I remember I told you, Section 2119, a carjacking or attempted carjacking resulting in a serious bodily injury and or resulting in death. It's a general intent offense. Okay, the Supreme Court affirmed the federal carjacking law applies to defendants with the conditional intent of harming drivers who resist. So it's not necessary that you have to resist, but it does put you in that position. This person, Holloway, was convicted of carjacking, and he and his companions had approached the vehicle, threatened to kill them if they didn't turn over the keys. The trial judge instructed the jury that the conditional intent requirement was met as long as the defendant intended. Doesn't matter whether they actually did, just intended to create it. Or they had a weapon, or maybe they didn't show the weapon, but maybe they made them believe they had a weapon. Same thing. So when we get to a little comparison of robbery, again, taking money or property from a person against that person's will by means of force or intimidation. Property is taken by threat of force without consent, and there's a felonious taking property off of the victim's person. Remember that, or immediate presence, You got to be careful about stretching that, though. Some of you tried to stretch it, but again, you got to be real careful. It means what it says, person or immediate presence, and the contextual nature of how it's written makes it more likely that you have to have been right there with that person and requires a general intent. On the other hand, extortion, obtaining money or property by threats or force, inducement of fear, blackmailing the person, taken by the threat or force with consent. So the person agrees to consent because of the possible threat. Property does not have to be taken from the victim's person or immediate presence. Requires specific intent. Remember those differences. Forgery, making of a false written instrument, altering it, changing it. Notice the example here, altering grades on a college transcript. That's a felony, and also that can send you to jail. A lot of people don't realize that, but it's a very serious offense. A lot of hackers now, we don't have it as much now, going in and changing grades. But you've seen movies like that. You saw Ferris Bueller, and they did something like that there. But anyway, it's with the sophisticated software that we have now to protect. The bottom line is that making a false statement through writing is forgery. Under federal law, the prosecution must prove the intent to pass bad money. You must know what it is. Counterfeiting, making intimidation of something with the intent to deceive. For example, making imitations of coins and currency. Did you not know, people, that it is a violation of the law to make copies of money? And then, there are people who don't know that, but that is a violation of the law as well. We're almost done here. Hitler's diaries. I always like to take time to go over this one. This is a very interesting scenario of forgery. In 1983, the popular West German magazine Stern made the shocking announcement that they had 62 handwritten diaries from Hitler. Now, the problem with that, though, is that the diaries went against what people knew about Hitler and his character and his action, presenting him as more amiable than had been documented. And people who had known Hitler were shocked because they said, that doesn't sound like the Hitler we know. Well, after a few weeks, it was discovered that the diaries were forgeries. Even though, listen to this, the Stern had asked experts to verify the authenticity of the diaries. So how could that happen? Well, the experts compared the diaries to original documents that were also forged by the same person. So there we go, right there. So a forgery on a forgery can produce the appearance of being authentic when it really is not. Okay, that's the point. Uttering a forged instrument, passing a false, a worthless instrument such as a check with intent to defraud. The utter distinguish the actual forgery from the act of passing a forged instrument. Knowingly delivering a forged check, classified as a felony. Don't do it. Worthless check. At the beginning of banking business, bad checks was a big, serious issue, and it was not classified as forgery. But now states have passed what we call worthless check statutes, and usually these are misdemeanors. Offenders have to pay a fee. You've seen that if your check is returned, maybe $25 or something like that, you end up having to pay. So offenders have to pay a fee. Recipients often tell customers what the fee is for that. But if you don't make those checks good, sometimes in some jurisdictions, including Illinois, you can be prosecuted for misdemeanor. Burglary. Okay, people, let's talk about this. We got a few more minutes. That's about 9:59. I may go 5 minutes over, but because we're almost done. Breaking and entering of a dwelling of another. Now, if you read the material in your module, it'll say breaking and entry of another in the nighttime. Burglary used to be a crime that had to be committed in the nighttime. But now that's no longer. The nighttime requirement doesn't exist. It could be 24/7. It could be daylight. But a person is guilty of burglary regardless of lawful entry of the dwelling. For example, intentionally remaining in a grocery store or department store with intent to commit an offense therein after the store closes for the day. I had a young man I represented one time, and he stayed in a Kmart, hid in the bathroom, and then when the store was locked and closed, people were still there. He came out and announced that he was, and he had a little gun. It wasn't a real gun, later we discovered. Anyway, the people, gave him, and then they threatened him, so he tried to get away, and he jumped through a plate glass window. Well, he passed out, and guess what? That's how he got arrested. And so, talking about a crazy crime. But anyway, a burglary committed where home invasion, where a person is armed with a dangerous weapon, possession of burglar tools. Now, let me explain something to you. If, for example, you even so much as not completely enter into a building. But let's say, for example, and I'm telling you this because that's why it's good to come to these lectures. If you find yourself in a situation and you see a window open and there's a computer sitting there or something value, and you reach inside that window and open and take that, you committed burglary because you've broken the plane of outside and inside. We used to call it a curtilage back in the old law. You have to go to law school historically and understand that. But the point of the matter is, it's sacred. Your stuff should not be, just because the window's open. It might be stupid to do it, but the point of the matter is, it's still burglary. Okay? So it's not necessary that you climb through the window. All right? Arson, essentially burning someone's house or building, now commonly extends to vehicles and structures, and in many states, proof of damage of smoke and scorching is adequate for arson. Prosecution only has to prove that the person intended the act. It can be a felony or misdemeanor depending upon the circumstances. Of course, burning property with the intent to defraud an insurance company is a specific intent crime and that's a felony. That is a felony. All right. So if you get to a point that you are creating arson in a situation where people might be occupying the place, then you're getting into the felonious aspect. But here's an example of a serial arsonist. This is a very interesting case where a former fire captain and arson investigator in California set a series of fires. Yep, that's what I said. The former fire and arson investigator was setting the fires during the 80s and 90s. And the fires always started around highways and near arson investigation conventions. Well, eventually, the John Orr, the former fire captain, was arrested after police matched a fingerprint on a time delay device, and he was sentenced to life in prison. The reason why is because he was creating a danger. And I don't know if people were killed, but there were people who could have been seriously injured in that situation. Okay, it could have created a stampede situation as well. Malicious mischief, just plain old vandalism. Willful destruction of property of another, such as writing graffiti, interruption or impairment of transportation, sending in another direction, reconnecting your water, your gas, or electric after it's been turned off, those kinds of things. Those are usually considered as misdemeanors. Defenses to property crimes, and this is the last slide here. Mistake of fact. So if you unintentionally take the wrong item, then you could argue it was a mistake of fact. However, if you determine at some point that you got the wrong thing and then you decide, oh, well, I'm just going to keep it, now it's no longer a defense because you should take the steps to try to return that. Mistake of law, such as debating on whether or not there's ownership rights, that's usually getting into civil issues. Lack of intent. I inadvertently did this. Alibi, whatever that means in terms of defenses of property crimes, you didn't do it. Somebody else did it, and you were someplace else, or they got you mixed up. Insanity, very, very hard thing to prove. Duress, very hard to prove because you have to prove that you committed the crime because you were forced by someone and that they had what we call gun at head duress, which meant there was some imminent danger to you, and that's why you committed the property crime. Intoxication, well, people, I'm here to tell you, if the intoxication is involuntary, you might have a case. But if it's voluntary, in other words, you did it negligently, you just drank and then committed the crime, not going to be an adequate defense. So those are the issues that we deal with in terms of this week with the two chapters that we had. And so are there any questions? You should have some nuggets based upon the lecture that will help you with your written assignment on the rape and the rape shield laws, and then also um, dealing with the discussion posts to determine whether robbery, theft, burglary took place. So it's about 10:07 p.m. Okay, let me see what you said. Um, make sure you do it publicly. Well, it's generally considered as a felony. Let's say, for example, you do it with an empty building, and it's not, you're trying to collect insurance, then it's probably a misdemeanor. But as soon as you get to the point that the arson creates a possible danger to someone or individuals, then it crosses over into felony. Okay? Does that clarify that for you? Okay. Any other questions? Okay, great. Um, okay. Seems like there's nothing else. So at this time, I'm going to say good night to each of you. Thank you for coming out tonight and being with us. No, there is none. There's no code word in these lectures because they are, you don't get graded on attending the lectures. If there was a requirement for grading and it had something to do with an assignment, then the answer is yes, I would do that. I do that in classes that I teach that are what they call online plus courses. And students are required to attend the lectures. So no, so we don't have to deal with that. All right, so with that, I'm going to say good night. Again, 2 weeks, we will have our very next lecture. One of the things I do wish, and I say this over and over again, that I have a lot of students who don't come to the lectures, and some can and don't because it's not mandatory. But I do say this, and I say this all the time. The students who perform at a higher level generally will take the time to come to the lectures because they are able to ask questions firsthand, and then also they can get information, and you can contemporaneously get the answer to your questions. So anyway, with that, I will see you in 2 weeks, week 6, with our very next lecture. So again, you know how to reach me if you have any questions or concerns, and I will be happy to address them for you. So I'm going to say good night and end the meeting.